Welcome, everyone. Thank you for being here. Very exciting day. I am really pleased and honored to be joined by such great advocates and champions of women's health care who are here today. This day is really, I think, profoundly significant for that fight for women's health care. We are announcing today the introduction of the Women's Health Care Protection Act to create strong, important federal protections, clear and certain protections for essential women's health care, personal decisions, and constitutional rights. This measure is necessary because of the cascading increase across the country of measures at the state level, sponsored relentlessly by anti-choice legislators who are determined to place barriers and obstacles in the way of women who want to continue to make personal decisions about their lives. These increases have been absolutely astonishing. In 2011 alone, there were about 92 restrictions on abortion rights. Since then, there have been 100 more. They range from requirements that clinics have certain layouts to regimens for medicine that are outmoded and unnecessary, to counseling requirements at crisis pregnancy centers. Across the board, what these measures have in common are that they use healthcare as a false pretext and ploy to restrict women's healthcare decisions. And this bill sends a message to those anti-choice legislators that those measures are going to be invalidated. They will be barred by a federal statute relying on the federal Constitution, the Commerce Clause, and the 14th Amendment. This measure is firmly rooted in the United States Supreme Court's decisions that protect a woman's right to choose. It very simply enables access to health care that is vitally important to women to make real the rights they have under the Constitution, to make sure that women are not barred because of the zip code in which they live from exercising those rights. There is a very solid precedent for this decision in federal statutes when federal rights are threatened to protect those rights. Other measures in the past have relied on these same constitutional clauses, and so I feel very comfortable that this measure will be upheld. And I also am encouraged by the fact that there's growing support across the country and in the Senate. We're now up to 29 co-sponsors, which is very, very heartening. But most important are the advocates in the House of Representatives, and we're going to hear from two of them today, and the activists across the country. You are the ones who are making possible this step toward protecting rights. Citizen advocates who are standing strong and speaking out and letting us know what the practical effects of these anti-choice measures, the ploys that rely on women's health only to restrict women's health care decisions. And you're standing strong and speaking out are what give us the essential support that we need to make this measure successful. And have no doubt, this measure will be successful. It may not be today, may not be next week, but we will win this fight. And the reasons that we're going to win it are people like Senator Baldwin, Senator Boxer, Representative Chu, Representative Fudge, and Representative Frankel. You will hear from them. And then from Walter Dellinger, one of my legal heroes as an advocate, as a Supreme Court advocate, and also Nancy Northrup, who is unexcelled as a champion and advocate. So let me just begin by asking Tammy Baldwin to come forward.
Thank you. Thank you, Senator Blumenthal, for your leadership on this issue. You know, Americans across this country expect to have access to high quality and dependable health care when they and their families need it. Unfortunately for women in this country, this access has come under attack. As my colleagues and I have worked to reform our entire healthcare system to expand access to quality, affordable health care, many states have enacted scores of laws to restrict a woman's access to comprehensive reproductive health care and a woman's freedom to make her own health care decisions. In my home state of Wisconsin, politicians have been standing between women and their doctors, restricting the choices that women can make regarding their own reproductive health. Women and their doctors are facing a slew of new and radical restrictions to health services that have been passed by our Republican legislature and signed into law by our Republican governor. Most recently, our governor signed a law that not only forces women to undergo unnecessary medical procedures, but also imposes unreasonable requirements on the doctors that deliver care to these women. This extreme mandate would force several Wisconsin health clinics to shut their doors and others to reduce services, leaving many women out in the cold. These politicians in Wisconsin and in many other states across the country are doing this because they think they know better than women and their doctors. But the fact is that they don't. It's not the job of a politician to play doctor and to dictate how these professionals practice medicine, nor is it their job to intrude into the private lives and important decisions of American families. That is why I am so proud to stand with my colleagues here today, including my good friend from Connecticut, and stand up to these attacks on women's freedoms. I am proud to introduce the Women's Health Protection Act because every American woman deserves the freedom to exercise her constitutional rights by making personal health decisions for herself and her family with a trusted doctor and without political interference. Our bill makes it clear that states can no longer enact laws that unduly limit access to reproductive health services, laws that do nothing to further women's health or safety. The Women's Health Protection Act creates federal protections against state restrictions that fail to protect women's health and intrude upon personal decision-making. It promotes and protects a woman's individual constitutional rights and ensures her rights to make her own responsible health decisions, no matter where she lives. Elected officials shouldn't put politics before women's health and safety. Women are more than capable of making their own personal medical decisions without consulting their legislator. And every woman in America deserves the freedom to plan her own family and make her own healthcare decisions and access essential quality women's healthcare services. We need to act now. We need to act now to guarantee that women have that freedom. We need to act now to protect a woman's access to care and her constitutional rights, no matter where she lives, by enacting the Women's Health Protection Act. In addition to working with the senator from Connecticut and the senator from California, who we'll hear from later, this is a joyous reunion with some of my former House colleagues, and I'd like to call to the podium Representative Chu.
Well, thank you, Senator Boxer. Today, we take an important step forward in ensuring affordable access to safe medical care for all women, regardless of what state they live in. And I want to thank Senators Blumenthal and Baldwin for taking the lead on this bill, as well as Senator Boxer's support, and also on the House side, the co-leads, Congressmembers Fudge and Frankel, for supporting this bill, which carries out the promise of Roe versus Wade and protects a woman's right to choose all across this nation. Roe versus Wade allowed every woman the right to make decisions about her own body, including the deeply personal decision to continue or end a pregnancy. But opponents of reproductive freedom are trying to undercut this right. They've gone to individual states throughout this country and signed into law restrictive regulations that single out abortion services. They passed 92 restrictions in 2011 alone and 100 since then. These are laws that, like those that was just reinstated in Texas, which requires doctors to perform abortion procedures only if they have formal admitting privileges at a hospital within 30 miles of the clinic. This new obstacle forced nearly 1/3 of all clinics in the state to close their doors. For women in Texas, this means longer waits, higher costs, and canceled appointments. Some women would have to travel over 150 miles to find a provider, and others who've been saving money for the appointment may no longer be able to afford the procedure they need. This puts too many women into desperate circumstances. These laws do not advance women's health or safety as they claim, but achieve only one goal, and that is to block women's constitutional right to privacy and strip away the ability to choose what happens within their own body. Well, enough is enough. We've been playing defense far too long. It's time to stop playing whack-a-mole in each state, and we need to provide a national response in fighting this. The bill that we introduced today does just that. The Women's Health Protection Act aims to end discrimination against abortion access for women based on their zip code. It would create federal protections against restrictive state laws that single out abortion services and shut down clinics all across the country. Now, we've gotten such an enthusiastic response on the House side. Just in a matter of a few days, we now have 53 co-sponsors. This is one part of a greater effort to ensure access to abortion on all fronts. We still have a lot of work to do on the Hyde Amendment and other issues such as harmful requirements for parental notification and consent laws. But constitutional rights should never be subject to the personal whims or beliefs of political leaders, nor should the safety of mothers, daughters, sisters, or wives be jeopardized in the process. Personal medical decisions belong solely to the people they impact and the medical professions they trust. The Women's Health Protection Act will restore the ability for women to make those decisions. We recognize that without the ability to access it, the right to abortion is meaningless. I urge my colleagues both in the House and Senate to support this bill. And now, it is my great pleasure to introduce the Senator from California, Barbara Boxer.
Thank you so much. Well, the fight goes on, and I'm so proud to be here with my colleagues from the House. And I did serve in the House for 10 years, so I have a little spot there it warms my heart to see Congresswomen here. And I just want to give a shout out to my Senate friends, Tammy Baldwin, who's helping us make history every day. And I do want to say about Senator Blumenthal, how wonderful is it to have a man stand side by side with the women of the Senate. And Senator, I've told you this many times. It's not just when we're in front of, trust me, it's not just when we're in front of the cameras and the microphones. He's there with us, strategizing, standing with us. It is just wonderful. And so I'm so proud to be on his bill. And, we're basically saying today that we're gonna stand up to these dangerous laws that are harming women across the country. 92 of them, which it felt like even more. But these laws are vicious. They're vicious. They're hurtful. They're harmful. And we are saying today, enough is enough, and we're going to stand sentry. Richard is such a good lawyer, and I'm not a lawyer, but my husband's a lawyer, my father was a lawyer, my son's a lawyer, so I have by osmosis a little bit. And what we really do in this bill is we codify Roe v. Wade and all the other decisions that have been made so that we don't have to fight these battles state by state by state by state. It becomes very, very difficult. In states like Kansas, Missouri, and the Carolinas, we've seen absurd requirements. For example, building requirements for clinics only have one goal. You know, you have to have a hall this wide, you have to have so many doors. This is just meant to put costs on the backs of these clinics, these women's clinics, and they want to shut them down, and they're shutting them down. And that's why we're here today. They want to shut doctors down. Doctors are in danger. And in addition, they're trying to shut them down. So we've seen disgraceful ultrasound laws. We've seen extreme abortion bans. And frankly, it's not just in the states. The other day, one of our Republican friends said that he has introduced a bill that would outlaw ban abortions pre-viability, and it's outrageous, and it puts women in extreme danger, extreme danger. So this Women's Health Protection Act is a perfect name for this bill. We need to protect women from politicians who play with their lives. Our bill protects millions of women, regardless of the state, regardless of who their governor is, or, you know, again, as Tammy Baldwin said, when we make personal decisions, we want to make them with our family and with our God. It's our choice. And no politician has a right to be anywhere near that room. And we have to trust women once again. And that's what this bill is about. So, frankly, to me, this is a no-brainer. I've been fighting this battle for so long. I thought it was finished when the court decided Roe, but we've learned something about our country, that the arc bends in the right direction, the arc of history, but we got to bend it to make sure, because otherwise it may bend in the wrong direction. And we're here today to say, no way. We're going to work together, we're going to fight together, and we're going to protect the women of America. Thank you, Richard. Thank you, Tammy.
And now my co-lead on this bill, Congressmember Marcia Fudge.
Thank you. Good afternoon. Thank you so much. Let me thank my colleagues, Representatives Chu and Frankel, and of course, Senators Blumenthal, Baldwin, and Boxer, for their leadership on protecting and reinforcing a woman's ability to make personal decisions regarding her reproductive rights. I also want to thank the Center for Reproductive Rights, NARAL Pro-Choice America, Planned Parenthood Federation of America, and ACLU for their strong support of the Women's Health Protection Act. The right to privacy, which was the basis for Roe v. Wade and is in fact rooted in the 14th Amendment, establishes a constitutional right for women to make decisions about their reproductive health. Yet many state politicians have chosen to insert themselves into complicated and private medical decisions that should be left up to women and their families to make, for women and their families to make by enacting restrictive laws. These are the same people that talk about limited government, the same people that talk about less intrusive government. Hypocrites they are. That's why I'm proud to co-introduce the Women's Health Protection Act of 2013, which would protect a woman's constitutional right to access safe and legal abortion services regardless of where she lives. Our legislation would make it unlawful for states to pass restrictive legislation that endangers women's health and safety and interferes with their personal medical decisions. For example, states would no longer be able to enact laws requiring doctors to inquire as to why a woman wants an abortion, or require women to visit a crisis pregnancy center prior to obtaining an abortion. Earlier this year, my home state of Ohio passed a budget bill, mind you, I'm saying budget bill, that defunds Planned Parenthood and restricts grants to rape crisis centers that refer women to abortion clinics. This budget bill also requires abortion clinics to transfer patients to a local hospital in the case of an emergency, but it prohibits public local hospitals from entering into agreements with these people. Together, these actions have severely limited a woman's ability to exercise her reproductive rights in the state of Ohio. Just this year alone, 4 abortion clinics around the state have closed, including the latest one, the Cleveland Center for Women's Health, which closed on September 30th. The state of Ohio now has 11 clinics in 9 cities that offer abortion services. Restrictive laws like the one passed in Ohio make it extremely difficult and sometimes nearly impossible for a woman to obtain essential reproductive health services. Ohio's effort to limit and dismantle women's reproductive rights are not an isolated occurrence, as you have heard. In fact, there has been an all-out legislative assault on women's rights during the last 2 years. And since 2011, there have been more than 90 restrictive laws passed across this country. Even though the landmark case of Roe v. Wade made it clear that women have a constitutional right to make decisions about their health, many states have tried to roll back these provisions and protections through harmful legislation designed to impede a woman's ability to make what should be personal choices. The Women's Health Protection Act would put a stop to this awful trend. The 14th Amendment must be respected, especially for those who read it at the start of every Congress. Roe v. Wade must be respected, and a woman's reproductive rights must be respected. Thank you.
Good afternoon. I'm Lois Frankel from Florida. First, I want to thank my colleagues for their leadership in this issue, and also especially thank the service providers that are represented for being on the front lines for us. So I want to tell a story. When I was a teen, I found a friend bleeding near death, the victim of an illegal abortion. It was in the 1960s, and she was a young, frightened girl with no one to turn to. And she did what many young girls like her were forced to in those days. She was forced to turn to a back alley practitioner. Unfortunately, she survived, but her name was Flora. There were many Floras, as you know, that did not survive or who were terribly maimed. And that all preceded the Roe v. Wade case, where the United States Supreme Court ruled, as has been said many times, that our Constitution gives women the right to make our own personal, private health care decisions. And over the past 40 years, we've seen an erosion of Roe v. Wade and obstacles. We have the right, but now we see the obstacles that keep us from having the ability to exercise that right. The Women's Health Care Protection Act will allow all women, no matter where they live or travel in our great country, to the right and the ability to have access to the tools and information that we need to make important life-changing decisions. Anti-choice legislators in my home state, Florida, all across the country, in Washington, they want to take us back to those alleys, and we will not go back. Thank you.
In the 40 years since the Supreme Court declared that women have a constitutional right to make the reproductive decisions that affect their lives, we have seen an increasing erosion of that right, and measure after measure which increasingly inhibit the access to actually effectuate that right, so that it is a right in reality and not merely a right in theory. The Women's Health Protection Act would play a vital role in setting aside that panoply of restrictions, the cumulative effect of which is to prevent women from making their own choices and their own decisions about these vital matters. It would do so by setting a national legislative standard enacted by Congress that would provide that you may not impose restrictions that are not necessary for women's health, that burden access to reproductive choice, and that are not applied to comparable medical procedures and are done for the purpose of making it harder for women to access their health. This is undoubtedly constitutional. The bill that has been drafted is predicated on both the 14th Amendment and the commerce power. And to look for an analogy, just look at what happened with respect to the Freedom of Access to Clinic Entrances Act. Congress in the early 1990s enacted legislation to prevent people from physically blocking the access to clinics. And every single court of appeals upheld the act as the proper exercise of the commerce power, saying, as the Fourth Circuit did, that physical obstructions aimed at persons seeking reproductive health services clearly affect interstate commerce. These are not physical obstructions. These are regulatory obstructions that have the same effect. That is, instead of blocking the entrance to the building, they use regulations under the guise of women's health that shut those buildings down. And they equally burden access to these vital goods and services that are available in interstate commerce. I have no doubt that the same result will obtain here, and that every court will sustain this act. Some will no doubt suggest that opposition to the functioning of these health clinics is based often on social or moral grounds and not economic grounds, but that was true of the opposition to allowing access to public accommodations by persons of color. And the Civil Rights Act of 1964 was one of the most important uses of the commerce power ever to end that national blight. But one thing I want to make clear is that what this national legislation would do, as well as setting aside those panoply of unnecessary and harmful restrictions, is that it would place this issue beyond where slipperiness in the courts could cause backsliding. No matter what the courts would do, how insecure the courts would become, this would be there as a national legislative protection for the exercise of reproductive rights. And it would not just protect reproductive rights, but access to those other services that are vital and made available, like mammograms and testing for cervical cancer, access to contraceptions. All of those are being burdened and inhibited by the panoply of state and local rules that this legislation would set aside. So finally, I think what we can see is that this legislation, fully justified under the commerce power, is not just about commerce, it's about freedom. And no one can really be free in this country as long as there are women who are unable to effectuate those decisions that so affect their lives. And we want to make sure that another generation can come of age secure in the knowledge that the reproductive choices that affect their lives and those of their families are their choices to make. This bill will do that.
Good afternoon. I'm Nancy Northup, CEO of the Center for Reproductive Rights. Thank you to Senators Blumenthal and Baldwin and Representatives Chu and Fudge and Frankel and all of the co-sponsors of the Women's Health Protection Act. Thank you for your leadership and your courage in drawing the line against these unprecedented assaults on women's health and rights. The Center for Reproductive Rights was founded 21 years ago with a straightforward mission: to advance reproductive health and decision-making as a fundamental human right that all governments around the world must protect and respect and fulfill. And with offices around the world, we do that day in and day out. There are almost 200 countries in the world and 200 examples of what government policy on reproductive health can do to either advance women's well-being, dignity, and equal citizenship, or to undermine it with devastating consequences. In this last decade, as we've seen these assaults here in the United States, we've seen globally amazing advances in recognizing reproductive rights as fundamental human rights. To mention just one, in 2006, the highest court of Colombia declared that country's blanket ban on abortion unconstitutional. I get inspiration from listening and rereading those words of the court. It declared, quote, "Reproductive rights emerge from the recognition that equality in general, gender equality in particular, and the emancipation of women and girls are essential to society. Protecting sexual and reproductive rights is a direct path to promoting the dignity of all human beings and a step forward in humanity's advancement towards social justice. Protecting reproductive rights is a direct path to promoting the dignity of all human beings and advancing social justice. So what in the world is going on in the United States? Never would I have thought, when the center was founded 21 years ago, that we would be here today fighting the onslaught of vicious attacks that seek to turn back the clock on women's health and fair treatment. Yet some of our toughest fights are right here in the United States. We have had to bring numerous lawsuits against a record-smashing avalanche of legislative attacks that are closing down reproductive health clinics, denying women the dignity of making their own decisions, and sending all of us hurling backwards to the various dark and dangerous days pre-Roe. The last clinics in Mississippi and North Dakota are hanging on by a court order. In Texas, we're fighting alongside our colleagues from Planned Parenthood and the ACLU against an underhanded law that has closed the door on abortion services of a third of the clinics in that state. Just yesterday, we thankfully heard from the United States Supreme Court that it will let stand a victory that struck Oklahoma's intrusive and demeaning forced ultrasound law. We have successfully sued Oklahoma, as one example, again and again and again, as they relentlessly seek to drive the few remaining providers in that state out of practice and eliminate the availability of abortion services for all women in the state. But the women in Oklahoma, in North Carolina, in Wisconsin, in Ohio, in Texas, and across the nation should not have to go to court to have their rights protected. In 1994, as Walter mentioned, Congress acted decisively in passing the Freedom of Access to Clinic Entrances Act to stop the violence, blockades, and harassment that had reached a crisis level in impeding women's access to abortion services. We are at a crisis level again today, and we need decisive congressional action now. The Women's Health Protection Act is that decisive action. So again, thank you to our stalwarts in Congress for sponsoring the Women's Health Protection Act. And today is just the beginning. I promise our full, vocal, energetic, and unwavering support as we march forward towards the realization of our Constitution's promise of equal protection under the law for all women everywhere across the nation. Thank you.
Thank you, Nancy, and thank you to all who are championing the Women's Health Protection Act. I'm Alexis McGill Johnson, and I am the chair of the board of Planned Parenthood Federation of America. And I'm proud to be here today on behalf of the 3 million women, men, and young people who count on Planned Parenthood for health care each year and who count on tireless champions such as yourselves to fight for women's health in Washington. Now, it's not news to anyone here this afternoon, and it's certainly not news to women in America, that we are currently weathering one of the toughest political climates we've ever seen when it comes to attacks on women's health and rights. As the country's leading women's health care provider and advocate, we have seen firsthand the devastating impact these restrictions have on women, cutting off thousands not only from safe and legal abortion, but from the life-saving preventive care we can also provide. These last few weeks, all eyes have been on Texas, where abortion has been effectively banned in parts of the state as some of the harshest restrictions in the country have taken effect. Overnight, women who made the deeply personal, deeply complex decision to end a pregnancy were prevented from exercising their constitutional right. But Texas is only the latest example, because what's happening in the Lone Star State is happening across the country. South Dakota recently passed an unprecedented 72-hour mandatory waiting period for women seeking abortion. Then they took it a step further by clarifying that it was actually 72 business hours. Wisconsin and Alabama have put in place dangerous and extreme restrictions whose sole purpose is to force providers of safe and legal abortion to close their doors. And a dozen states have passed unconstitutional bans on abortion in direct conflict with Roe v. Wade. I have to tell you, I appreciate your words, Counselor, that as a Black woman who was raised in the backdrop of both the civil rights movement and the women's movement, when I see politicians roll back access to basic health care for women, what I'm seeing really are the poll taxes and literacy tests that existed more than 50 years ago. But today, it feels great. It feels that there's a momentous time for us to come together and work to expand women's health, where we are in this room across the hill to support proactive efforts to ensure that women have access to a full range of reproductive health services. The Women's Health Protection Act would make it unlawful for politicians to interfere with women's personal health care decisions and ensure that our constitutional rights don't depend on our zip codes. Women across the country face many challenges to accessing safe and legal abortion, from funding to parental notification to harassment of patients and many, many more. The bill being introduced today addresses the restrictions we're seeing in state after state that were actually passed in the name of protecting women's health and safety, but are having the exact opposite effect. These laws have no basis in medicine. They have no basis in the real-life experiences of women across this country. They are dangerous, they are extreme, and they are deeply unpopular. Planned Parenthood will continue to fight these dangerous laws everywhere we can, from the state houses to the courthouses to Capitol Hill, and we are deeply, deeply grateful for the leadership of Senators Blumenthal and Baldwin and Boxer and Representatives Chu, Frankel, and Fudge for introducing proactive legislation to combat these attacks on women's health and for standing up for women across the country. Thank you.
Hi, I'm Elise Hogue. I am the president of NARAL Pro-Choice America, and as the rookie on the team, I'm going to back cleanup here. I'm really, really honored to be here and very thankful to the leadership of Senators Blumenthal and Senators Baldwin for their enthusiastic introduction of the Women's Health Protection Act. You've heard a lot about why and what we're fighting. I want to talk about how these things are happening. One of the things that Representative Fudge talked about was the Ohio restrictions taking place in the budget bill, not born the opportunity of public debate, not seeing the sunlight of day where the public can debate it. We saw the same thing in Texas, where Governor Perry and the state legislature broke the rules of democracy to ram through a set of ideologically extreme restrictions on women's reproductive freedom. And how about North Carolina, where they actually attached these restrictions on our reproductive freedom to a motorcycle safety law? There is a reason that these things are happening through broken rules and in the dark of night. The reason is that our extreme opponents understand that the public is not with them. 70% of this country supports Roe v. Wade. On the 40th anniversary, the Wall Street Journal said so. An in-depth expose in Esquire magazine on the New American Center, that coveted demographic that everybody wants to figure out, showed that 63% of New American Center supports abortion for almost any reason. This is a mainstream sentiment and a mainstream feeling that women can make our own decisions freely and privately with our families and our gods. This is mainstream. That is the reason we are seeing people rise up all over the country. I was honored to be in Texas. I am a native Texan, and to see tens of thousands of people show up at the Capitol to support Wendy Davis, to see hundreds of people join in Moral Mondays in North Carolina on behalf of women's reproductive freedom, and to see the voices of women and men and families all over this country raised in outrage against this onslaught, these attacks against our autonomy, our self-determination, and our freedom is the beginning. But I will tell you, as a new president, and as someone who, new president of an organization, there's another president, and as someone who identifies very strongly as an organizer and a movement builder, as I travel around the country, I hear from people all over, not only don't we want to go back, we want to go forward. We want to go forward with the real policies that support real women and real families living modern lives in 21st century America. As Representative Chu said, the Women's Health Protection Act is the first step on that. We will not stop. We will not stop. We have a duty to protect women of all races, all incomes, all ages, in their right to access health care equally around this country. But today is a great day. I say I didn't come from this movement, I came to this movement. The clarion call was the urgency, but I was really seduced by the opportunity. And the opportunity that this bill presents to give voice to the millions and millions and millions of Americans who agree with us to move forward into the future bravely and courageously is something I'm honored to be a part of. This movement will not stop. We are on the march, and today is the beginning of a new tomorrow. Thank you.
Thank you. Thank you all. I want to thank all of my colleagues, but I particularly want to thank our Center for Reproductive Rights, the ACLU, and Planned Parenthood, and NARAL Pro-Choice, and Professor Dellinger for being here today. Thank you so much. It's really, as I said before, the citizen activists who are going to get this done. And I also want to pay tribute to the hundreds, thousands of folks who are working in the clinics across the country, often in great personal danger. And as someone who first enforced the FACE statute as a state attorney general, I can tell you it's real physical danger. It's not just words or rhetoric that they brave. It is the physical threats of caring for women when they need that health care. So a great thank you to them. Any questions? Yep. You know, as I mentioned at the beginning, this measure won't become law tomorrow or maybe next week or even this year. But I think candidates are going to be asked in this next congressional election, where do you stand on the Women's Health Protection Act? You say that you're pro-choice. Where do you stand on the Women's Health Protection Act? So that's why I say this bill has a sense of inevitability. It also sends a message to the state legislatures that this kind of cascading increase, the epidemic of measures that restrict women's health care, will not be tolerated. The more of these measures pass, the more powerful our movement is. Yep. This bill deals strictly, as Professor Dellinger said so well, with the kinds of barriers that are akin to the physical barriers that were placed in the way of women seeking reproductive health care services prior to the FACE statute. The issue of delay is one of those barriers when women are prevented, for example, by a 3-day waiting rule from seeking abortion services, or other kinds of false measures that, as a ploy, seek to invoke health or safety. They do not impose additional costs. No. The key phrase, the key way to understand this bill is, first, it establishes a set of per se violations. In other words, certain kinds of violations, like requiring that a doctor have admitting privileges that serve essentially no purpose at all in protecting women's health or safety, or the hallways in a clinic be a certain width, which has no relation to health or safety. And then it creates also an unspecified kind of violation that either delay or decrease the availability of reproductive health care. A state, by the way, can justify a measure if it shows that there is a real need for this kind of measure that purportedly protects health and safety, but it has to do it in the least restrictive way. And the basic principle is that there can be no restriction that is not also imposed on a medically comparable procedure. If they single out abortion or reproductive rights, it's going to fall foul of the act. It would include, these decisions will be made by doctors and patients, doctors and women, and they can make it for medically necessary reasons. It doesn't distinguish. Yes, sir. Well, ultimately, good question. Ultimately, many of these very effective advocates might have to go to court if state legislatures purposefully simply defy the law. But at some point, they will learn that the cost will be to themselves, cost in dollars, cost in credibility of supporting and favoring and passing a law that plainly will be struck down by the courts. And there would be some reassurance to the advocates and to the providers that the federal government is on their side and federal law supports them unequivocally and clearly. The uncertainty and lack of clarity is an enemy here. We do not, but you know, I'm hopeful that we will attract some. We're working on it. Did you have anything to add? Anyone? Any other questions? Thank you all. This is a great beginning and really appreciate your being here. Thank you.